that's the point of no return. The master of the game, bitch, better wait your turn. They say I smoke too much, but I'm still finna let shit burn. Let shit burn, let shit burn. Bad bitch, she gon' do just what I please. Amen, the way she dropped down to her knees. Magician shit, couple tricks on my sleeve. Magician shit, couple tricks on my sleeve. Don't ask me about nonsense, I'll piss all over your content. Man, y'all can't stand me, man, y'all can't wait to hate. Listen closely, let it resonate. Took a pill, now I'm super straight. Wrist froze like lemonade, making beat sets every day. All I wanted was a Pepsi, just one Pepsi. I just hit my spinal tap, bitch, I know there's no going back. Fucking me subliminally, suicidal tendencies. Fucking me subliminally, suicidal tendencies. P-O-N-R, that's the point of no return. The master of the game, bitch, better wait your turn. They say I smoke too much, but I'm still finna let shit burn. Let shit burn, let shit burn. P-O-N-R, that's the point of no return. The master of the game, bitch, better wait your turn. They say I smoke too much, but I'm still finna let shit burn. Let shit burn, let shit burn. Bad bitch, she gon' do just what I please. Amen, the way she dropped down to her knees. Magician shit, couple tricks on my sleeve. Magician shit, couple tricks on my sleeve. Don't ask me about nonsense, I'll piss all over your content. Man, y'all can't stand me, man, y'all can't wait to hate. Listen closely, let it resonate. Took a pill, now I'm super straight. Wrist froze like lemonade, making beat sets every day. All I wanted was a Pepsi, just one Pepsi. I just hit my spinal tap, bitch, I know there's no going back. Fucking me subliminally, suicidal tendencies. Fucking me subliminally, suicidal tendencies. P-O-N-R, that's the point of no.
Good morning. Happy Saturday. I actually checked that I wasn't muted before I started talking. So hello, good Saturday morning. And all of you people that have to work during the week and can't catch the live streams, welcome to the stream. Welcome to Jay is for Justice. My name is Jay and I'm your host. If you are new here, please consider subscribing to this channel. And if you like what you see in my videos, please give them a big thumbs up. So good morning. I love our Saturday morning chats because we're not in a hurry. So if you're new here, Saturday morning lives we're not in a big hurry to get through it. So get comfortable, get your coffee. This is our Saturday morning here at Jay is for Justice. Good morning, Miss Carrie. Carrie has not been here in a while. Hope everything's going well, Carrie. Like I said, we've got our weekday workers. One maiden night. Good morning. What's up, J Lord? Do you think listing his name in the title of the video raises his score for search quota that he wants? Asks Angel Sacco. Probably. But I mean, there's really no way around it, right? I mean, he knows that's going to happen. He knows that's going to happen. I don't know what is up with my chat box. Like all of a sudden it just goes and it's all there. Georgie, hello. Hey, Jessica. Good to see you again. Sydney, Australia. That is awesome. Hey, I just watched a have you guys heard of the Fritzl? I don't remember his first name, but Fritzl, his daughter, he locked her in the basement for like 24 years. And I think there's a movie called The Girl in the Basement on it. Anyways, my hairdresser told me about it yesterday. And so I was watching documentaries on it last night. That was a sick case. I still don't understand how he kept her in the basement. She birthed 7 children in this soundproof room. And this happened in Austria. And I don't know, Austria. It made my brain click. But he kept her down there and she birthed 7 children by her father. He was an absolute monster. Greetings from Finland. Good morning or afternoon or evening. It must be something like that in Finland right now. I know Angel Sacco says, I wish there was another way because he doesn't deserve anything. I know. I agree. Jenny W., another one of our weekday missers. Hello. She says, coffee. Check. J. Check. Gonna be a good morning. I hope so. It was in Austria, you guys. So if you guys are interested, we can go over that case. If you've never heard of it, it's quite shocking. It's quite shocking. Let me know if you are a replay crew, if you would like to see us cover that here. Yeah, Josef. That's it. Thank you, Mel Barrow. Josef Fritzl. Fritzeldorfer. Speaking of Fritzeldorfers, we're going to talk about Brian Kohberger. What's up, Jeff H? What's up, Mike Santa? And my beautiful auntie. Those are your 2 mods right now. If you need anything, feel free to at Cheryl T or at Mike Sanner. What's up, Anna? Robin and Chris are listening. Woohoo! All right, our stream is complete. We have Chris. We've got Chris with ears on this stream, so I've got to watch my P's and Q's. Hopefully you guys are eating some waffles and eggs and drinking some good coffee. Good morning, Chris and Robin. Oh, yeah, she was rescued alive. But get this, the end result was that he let 3 of the kids live upstairs with his wife and the other kids. What's up, Bullhorn Betty? He let 3 of them live and grow up upstairs. So they had to endure this a-hole's abuse. And then the other 3 lived in the basement with Elizabeth Fritzl, the daughter that was going to take off, and she was going to go live her own life, and she was going to be adventurous. He didn't want her to do that, so he trapped her when she turned 18. So 1 baby died, and he burned it, I think, in their like fireplace or something sick. It was really bad. Good morning, NorCal. Tough Tiff. I know. Waffles sound yummy. Bong is loaded, says NorCal Refrigeration. Getting at it early. And Leotech and Robin are your other mods. If you guys need anything, go ahead and at them during the stream. What up, Brooke E? Brooke E, I haven't seen you in forever. Jeff H, did they say no blood in the car? Now was it cleaned by a criminologist or by Jules and Vincent from Pulp Fiction? I have to admit here, I've never seen Pulp Fiction, so I can't comment on that, Jeff H. I know you guys are going to be like, why? You've never seen... I'm not a big movie person. What's up, Pink Banjo? Right, so this dude dropped these 3 babies off at the door at separate times, the dad, and put them on their doorstep and said, oh, here's the letter from our daughter. She had these babies. She's somewhere else living her life, but she can't take care of them. So she sent them here. So yeah, we'll cover it. It's crazy. Joanne Murdoch says, hi from Australia. It's 12:10 a.m. on the east coast of Australia. Yeah, he kept building on to this like apartment down there, and Elizabeth made it like as homey as she could for her kids. Good morning, Canada, Firefly. Yeah, we'll go over it. It's definitely a case like I've never heard before. Okay, me and you, Carrie, we're in the same boat, and they can all laugh at us. They're going to laugh at me anyways. So they're all going to laugh at you. I can't find my laugh at you bite, but you get the drift.
I don't know.
Tough Tiff says, I love waffles, and she laughs. I love John Travolta, and I've never watched Pulp Fiction. You know, I'm not a movie fan. I would rather watch something that's real. Good morning, Mandy S. Good morning, Lindsay. Peaky, good morning. All right, if I missed you, good morning. Before we get started, we're going to talk about our poll. I've got a poll up here, and it says, Musk and Zuckerberg are in a cage fight. Who wins? Mark, Elon, or neither? They both chicken out. They both chicken out.
Yeah.
Maybe I should put my headphones on. I have the soundbite. I just have to find it. I'm all out of sorts. Here. There we go. My chair is sinking. Oh, Peachy, only for you since it is Saturday.
For donuts.
You missed the David Dodson. Have you guys checked out the new merch store that I put up? I took a lot of time putting that thing up. If you could just look at it. Budget Dapper Dork is Chris. He says Pulp Fiction is real. All right.
Roly-poly, daddy's little Betty. Betty's gonna be a man someday.
Okay, Mike Sanner thinks it's going to be a joke. Or he thinks it's a joke, and the fight will be AI only. I wonder. I want it to be real. I just can't picture either one of them fighting. But let's get over to our boob tube and get this stream going. All right, let's talk about our poll for a second before we get started on all these new documents. There's so many. There is so many, guys. Okay, what up, Meep? Meep. I love the Roadrunner, by the way. The Roadrunner was one of my favorite characters. All right, so here we go. We got Mark and Elon. And Elon cracks me up. The shit he says on Twitter is so funny. All right, Elon and Mark, two of the Bay Area's and world's highest profile tech billionaires, have agreed to fight each other in a cage match. It is uncertain whether the match will actually take place, but the exchange has boosted traffic on Twitter, Instagram, and Facebook with an endless stream of choose your fighter memes. So who thinks this was planned to drive more traffic to the platforms? I think it did exactly what they wanted it to do, right? Jeff H., I don't know whether to be scared or impressed. Jeff H. says, my friend and I can speak to each other using almost all Pulp Fiction quotes. Elon, pressure. Robin says, Chris said Elon knows pressure points. I think he knows a lot more than that. I think he is subhuman. The idea for the physical confrontation took off in a series of viral messages posted to their respective social media platforms. Instigated by Musk, of course, on Twitter, responding to a report about Zuckerberg's plan to start a rival service called Threads on his Meta platforms. So Mark Zuckerberg wants to start a Twitter clone called Threads. Dragonfly says, I would rather a word and truth debate, Cage War. True that. True that. No, it's real, guys. Musk said in a tweet that the world was, quote, exclusively under Zuck's thumb with no other options. In a comment to that post, another Twitter user warned the Tesla and SpaceX owner about Zuckerberg's jiu-jitsu training. And Musk responded, quote, I'm up for a cage match if he is. Zuckerberg, the founder of Facebook, quickly fired back. Send me location, Zuckerberg wrote on a Wednesday night Instagram story that showed a screenshot of Musk's tweet, along another user's message telling the Twitter owner to, quote, start training. In response to Zuckerberg's location request on Wednesday, Musk proposed the Vegas Octagon. They even picked a location. He then joked about his fighting skills and workout routines, suggesting that the fight may not be serious. The Vegas Octagon hosts Ultimate Fighting Championship bouts in a fence ring. While the 39-year-old Zuckerberg has trained extensively in mixed martial arts, competing in his first jiu-jitsu tournament last month, the 51-year-old Musk revealed, quote, I almost never work out, except for picking up my kids and throwing them in the air. He also joked, I have this great move that I call the walrus, where I just lay on top of my opponent and do nothing. He is so wrong. He is so wrong. The story speaks for itself, a Meta spokesperson said in a statement, while Twitter's Medium email account responded with a poop emoji. Its standard automated response to reporters. So if media emails Twitter, they get an automatic reply of a poop emoji. That's hilarious. Wow.
Yeah, they're loud and beefy.
Musk is hilarious. All right, let's see what you guys think in the poll here. That is so funny. Yeah, I guess he's trained. I never knew any of this. So we have, in the result of our poll, we have 48% of you think Elon would win. 38% of you think that neither, they would both chicken out. And 13% of you say Mark. Only 13% of you, like, everybody thinks Mark Zuckerberg's a wuss. Yeah, it's definitely a marketing ploy, but you can't blame them. They got to do something. They've got to do something, and why not make it fun? And, they're not doing anything that's harming anyone or putting out anything fake. It's all in good fun. And I think that's cool. I think, I was thinking about this the other day, like, with the new generation, like the younger, I'm going to be 50, so I'm talking about my age right now, but like the younger generations behind me, the ones that are in their 20s right now, think about their mindset and like how much more, I know we joke around and call some of them snowflakes and stuff, but if you think about how much more compassionate and how much more in tune with like mental health and emotions and I don't know, just basic things that I think the generation before me was very stuffy and didn't talk about. I think we're going to see a lot more, not so stuffy, like more laid back CEOs, not the suit and tie stuffiness that you never hear from. We've got these guys tweeting and Facebooking, and it's crazy. It's crazy, but it's also just the world evolving. It's the world evolving. And we're going to be getting into the generation before me. We're going to be getting into that in our Given the Fallout podcast that Potato and I are putting together.
Given the fallout.
We're going to be starting with the late 50s into the 60s and then moving forward. And it's not going to be your grandmother's history podcast. That's for damn sure. Keanu Reeves knows Kung Fu, says Robin. Random fun fact of the day. All right, guys, let's get into, I have actually a sneak peek as well for the end of this stream for you guys of what is to come. I'm working on a video and I'm going to give you a little sneak peek into that. But now we're going to get into what you guys came for, and that is the Kohberger docs. And the one we left off with was the objection to the state's motion for protective order. Or wait, no. What we left off with was the defendant's shit. There's been a lot. Okay, order to shorten time. We went over that. Order regarding notice of hearing. I think we went over that one. This is the Zoom. No, we didn't. Jeez, oh, Pete's. This is the order to short. Okay. I think we did go over that. So there's a hearing on the 27th at 1:30 p.m. Pacific. So maybe we didn't. Dude, if there's that many, I'm gonna be like, what? There's that many files. These are all short though, supplementals. Do you guys remember what we left off on? Oh, listen to Leo Tech. She said, I came for you. Kohberger can kick rocks. No, I haven't seen The Matrix either. Pearl Strand, says, I work in Silicon Valley Tech. Our CEO used to lead meditation on Zoom. See what I mean? Yeah, so different. Oh, Jessica, I think Streamlabs just accidentally got you. You didn't do anything wrong, though. Okay, comes now. Brian C. Kohberger, by and through his attorney, Ann Taylor, hereby moves the court for an order shortening time for hearing the defendant's second motion to compel. Notice of hearing of June 27th at 1:30 p.m. for the second motion to compel. We're going to get into deets. Don't worry. Then we have the order to shorten time to hear the motion to compel. Like, he didn't want to wait, I don't think. So then the judge scheduled it for the 27th. Order regarding hearing. There's the Zoom information. So it says this court is mindful that limited courtroom capacity and potential travel restrictions may interfere with the victims and the defendant's family's ability to observe the court proceedings in this case. Therefore, in the event they are unable or prefer not to attend the proceeding in person, the court finds it necessary to make the court proceedings available via Zoom for the victims and the defendant's immediate family members under the following restrictions. And then they give the meeting ID and the passcode. And then it says the Zoom information above shall not be disseminated to anyone other than the victims and the defendant's immediate family members. Any recording or live streaming is prohibited. So only the victims and the defendant's family can go on the Zoom. Declaration of Ann C. Taylor. In support of defendant's third motion to compel. I, Ann C. Taylor, do state and declare. Counsel for Mr. Kohberger filed a specific request for discovery related to the DNA in this case, titled Defendant's Third Supplemental Request for Discovery. The state filed a specific response to that request. After reviewing the materials provided, the following remains to be discovered. Request 3 profiles uploaded to a DNA database. The state has provided information related to this request for the seized item, the knife sheath only. The defense has requested all DNA profiles, including 3 additional unidentified male DNA profiles developed during the course of law enforcement investigation. This information has not been supplied. So I have thoughts on this. Like, I think everyone wants to knee jerk and go, oh my God, the prosecution's screwing them over. They're not giving them this shit. There's other people that it could be. Let's take a step back and let's think about this statement here. And let's think about the games that Brian Kohberger has played up until now with his motions and such. You know, the games with Bethany and, you know what I'm getting at. The state has provided information related to this request for the seized item of the knife sheath only. The defense has requested all DNA profiles, including 3 additional unidentified male DNA profiles developed during the course of law enforcement investigation. I'm not a lawyer, but I would have to pay attention to the last sentence. Including 3 additional unidentified male DNA profiles developed during the course of law enforcement investigation. They could have DNA from that house of Jack or from Kaylee's body or Maddie's body, their clothes. I mean, do you remember when we listened to the Texas lab owner talk about how small of an amount of DNA they can use? If you touch my shoulder, they can use that DNA to find out who you are. I think there could have been DNA of Jack, DNA of Adam, DNA of Ethan. We don't know whose DNA that is. That doesn't mean he had accomplices. It doesn't mean that they have the wrong guy. But I think that's what Brian wants people to believe. See, he knows people are reading this. He knows this is a worldwide, global, huge case. So I think we have to take into consideration that not all of this is sinister. Some of it may be wanting to sound sinister, hence doubt. So hopefully it is something like that and the prosecution can supply it and put it to bed. But I think that if there is DNA of Jack or Adam or Ethan or any of these guy friends, he wants their names known because he wants to bring these guys to the stand. He wants these guys scrutinized. He wants to keep victimizing, in my opinion, over and over and over. Just because they could have had 50 additional DNA profiles. It doesn't mean there's another killer. Okay, so B. No. It says request 3 profiles updated to a database. The state has provided the profile for the seized item, the sheath only. He knows his is the only DNA on that sheath. Okay. He knows they provided that. Okay. You're telling me 1 in a whatever, more than there's people on this planet chance that it's someone else, which means there's really 0 chance that there's someone else. But he knows. He's like, okay, you gave us the knife. Now let's see those other profiles so I can pick at these other people to cast doubt. Request number 6, communications. The state has not provided all emails, text messages, electronic messages, or other messages and conversations regarding biological testing in this investigation. I mean, we don't know what, back to the DNA found during the investigation, there could have been DNA on Kaylee's bed. There could have been DNA on Bethany's bed. There could have been a male DNA on Dylan's bed. We don't know. We have no idea. We have no idea where this other DNA came from. DNA comes in all shapes and forms, and he wants to paint these girls in a bad light. And he wants to make them look like hoes. And I refuse to fall for it. I'm not falling for it. And I'm not going to do that to these victims or the surviving roommates until I see proof that these roommates did something wrong. I'm not doing that. And that's the way that people should be. They should be giving the benefit of the doubt. This dude's incarcerated for a reason. Bethany is not incarcerated. Dylan's not incarcerated. But we believe Brian more than them. There's something wrong with that thought process. Request 6, communications. So they're saying they didn't get emails, text messages from all the testing. Request 9 and 10, unexpected results and corrective actions. This request has been partially complied with. So they did it. However, it's not good enough for him. However, the response lacks the full scope of the request. Well, I'm not there yet. Mary. The response lacks the full scope of the request 6 months before and 6 months after testing related to this investigation. Further information relating to all lab personnel has not been provided. So if they didn't have anything to do with the investigation, he wants their information. Yeah, we're going to walk through this in order. I know some of you guys have read ahead, but I have not. Part of the third supplemental discovery request was for materials related to genetic genealogy testing. A, the state has objected to this request in its entirety and has filed a motion for a protective order. Counsel for Mr. Kohberger requests this court consider the contemporaneous objection to the state's motion and declarations in support of the motion to compel. The requested discovery is properly sought pursuant to Idaho Criminal Rule 16. This discovery is necessary to the preparation of Mr. Kohberger's defense. And then it says underneath that, counsel for Mr. Kohberger has reviewed the materials provided in this case regarding the DNA testing, lab reports, bench notes, and photographs. Further, experts in the field of genetic genealogy and DNA have consulted and offered information and guidance. The state acknowledges it used genetic genealogy testing in this case, but claims it does not have to produce the records in the specific request for discovery. The defense disagrees. So the only reason that the state said they don't want to release it is because it has hundreds of people's names. And he wants all of these names. Like, he wants all of this out there. And it just, you can't do that to people. Counsel has learned through consultation with experts and sources referenced below that the use of genetic genealogy databases does not necessarily lead to a single individual as a potential suspect, and that reports of these searches often reference multiple individuals for further investigation and DNA testing. In fact, the state acknowledges such in its motion for protective order when it acknowledges, quote, hundreds of relatives. The testing conducted by a private lab is completely different in nature than the testing done by forensic labs. Genetic genealogy labs do not generate a profile in the same way that forensic labs do, and there cannot be a direct comparison. The tests used by private labs are either SMP or whole sequencing. These tests are similar to the methods used by commercial services such as 23andMe and Ancestry. Based on information from experts in the field, I have learned that once a genetic genealogy profile is created and the testing by the private lab is completed, the profile is uploaded to a database that contains similar data from other individuals. Once the genetic genealogy profile is uploaded, the profile is compared within that database and relatives are identified. It is my understanding that once possible relatives have been identified, their identities are used to construct a family tree to identify possible suspects. And they explain this, the state explained this in their response. But what I understood in their response was that it wasn't the FBI, or it wasn't a private lab after all. That it was the FBI that actually did it, not a private lab. Did you guys also gather that from the last batch of documents? That it was a private lab that had it and then they halted it suddenly? Did you guys get that? Because I heard that in the last documents. That's kind of what I got. Dr. Melmo coming out of the woodwork. What's up, Dr. Melmo? She says, well, the DNA matches his, and if there are other DNA samples, so what? Kids in college will have DNA on their beds. Good grief. I agree. Detra Ed says he's saying he didn't do it because he didn't know them. Who's Jules? Are you guys calling me Jules? Yeah, he was watching people blame them in the beginning. So and that kind of fits in with his stats that he wanted to see how many times Jack D was Googled and Chief Fry and Brett Payne and himself. Yep, the sheath does not lie, says Dr. Melmo. This process leads to a pool of individuals rather than one specific individual. The possibility of other relatives who might be similar to Mr. Kohberger is extremely important to the defense in this case. The processes used in this method of ID may be extremely important to Mr. Kohberger's defense. The timing and steps utilized are extremely important to Mr. Kohberger's case, investigation, and defense. I have reviewed a copy of the Idaho State Police announcement dated July 28, 2021, where the Idaho State Police Forensic Lab secured a grant to fund genetic genealogy testing for unsolved Idaho cases. And then it says, see attached exhibit where they contracted with Othram Laboratories in Texas. The U.S. Department of Justice issued an interim policy for forensic genetic genealogy DNA analysis and search in 2019. The policy describes the process that law enforcement engages in during those searches and the results and limitations of the method. The identified individuals are, quote, one or more genetic associations. That means that the donor of the forensic or reference sample may be related to a service user. Emphasis added, which may require additional investigative work and testing. If a suspect is identified, the agency is required to retain all FGG profiles, account information, and data for potential use during prosecution and subsequent judicial proceedings. A new collaborative, National Tech Validation and Implementation Collaborative, was established in 2022. Its purpose is to collaborate and formulate methods and policy for labs and law enforcement to establish forensic investigative genetic genealogy programs. Remember, this is what he specialized in. This collaborative contributed to a forensic science journal. The publication includes contributors from Idaho, Rylan Nolan, the Idaho State Police Forensic Services, and Elena Minton, Office of the Attorney General, State of Idaho. Of particular note is the policy of release of information in accordance with rules of discovery. See attached Exhibit C. Exhibit C.
Hey, bro.
I am aware of specific news reports in this case regarding Mr. Kohberger's DNA, as published by the New York Times on June 11th, 2023. That, quote, FBI personnel worked with the profile that Othram had produced, spending days building out a family tree that began with distant relatives. The New York Times sources have more information than the state has disclosed to the defense. This New York Times article generated intense media coverage and interest, the scope of which is explained in the True Scope report attached as Exhibit D. Oh my God, he has more stats attached? Come on. Does he really? In addition, Mr. Kohberger's defense team has discussed the use of statistics in this case with experts who have informed me that the manner of identifying Mr. Kohberger via this type of search may have significant impacts on the statistical analysis of the CODIS profile generated by the Idaho State Police Lab. Without access to the actual genetic genealogy search methods and results, it is impossible for qualified experts to address these issues. Counsel for Mr. Kohberger notes that the state utilized a statistical analysis number to claim a high likelihood of a match between the DNA on the sheath and that of Mr. Kohberger. The state, by its own admission, has taken a number of steps to identify Mr. Kohberger as a match. The statistical probability is not an absolute. The size of comparison sample and the nature of the search are important to ascertain conclusion bias. Mr. Kohberger has a right to effective assistance of counsel. He has a right to confront evidence. Counsel must undertake a thorough investigation of all parts of the case the state brings against Mr. Kohberger. Kohberger spelled incorrectly by his own lawyer. As such, like a hamburger, as such, the genetic genealogy investigation and process is necessary for the defense team to do its job. Signed, Ann Taylor. Let's get to the exhibitees. The exhibitees are going to be where it's at.
Exhibit E. EXHIBITY.
Here's the memo they're talking about. I'm not reading through that. You guys can read that on your own, but this is Exhibit A. And then they go into this policy about what they have to do, and I'm definitely not reading through all of this right now. I want to get to his other exhibitees. Forensic Science International Synergy. This is just another reference from the Department of Justice and their genealogy. Okay. New York Times, Mike Baker article. 24 items. Look at a new DNA technique finally brought a breakthrough. In the weeks after 4 University of Idaho students were found slaughtered in a house near inside the hunt for a killer. Look at all of these. So who thinks, because we found out that they didn't even use Othram. The FBI pulled it from Othram, if I'm understanding this correctly. Oh, I know. They spell their own client wrong. Like, do they have, I don't think they have much respect for his ass. So fucking cool. I will put the link to the docs in the description of the video for you. So he's mad because they put out fake shit, probably. They probably leaked something wrong or something, because it doesn't sound like they used Othram. It sounded like, and if I have to go back, I will, but I could have sworn, good morning, jammers, but I could have sworn that we read that they didn't end up using Othram, that Othram had the sample, but then the FBI halted their testing. Geckles. This is a good point. She says, or he says, I'm sorry, could you imagine if the real killer was still out there? I don't think he would let BK have all that attention for his work if there was, right? I guess it depends on the motive for the killings, right? If it was, something like that the person got off on and, wanted to hear about, or if it was just like someone, mad. It depends on the motive to me, I think. The digital footprint will be amazing when it comes out. Google can trace your every step going back years. I agree with you, NorCal. I think this is going to be the most digital case we've seen yet. As for his Candy Girl, as for his name being misspelled, that was one typo out of the entire document. Right, but the client's name. I mean, it's not like they spelled, their wrong. It's his own name, spelled like a hamburger. I think it's funny. I think that kind of shit drives him nuts too. I think the audio issues with the court every time he has a hearing. I'll be interested to see if there's an audio issue on Tuesday at the hearing. All right, that's that for that one. Defendant's third motion to compel discovery. Comes now Brian Kohberger with his third supplemental request. Standard lab discovery. Profiles uploaded to a DNA database. Documentation of all uploads, including interpretation and or deconvolutions of mixed profiles, handwritten notes, spreadsheets, match estimator results, upload forms, and CODIS search forms. For each hit, provide match detail reports and long-form candidate match reports for the hits, including partial hits and hits that are dispositioned to be non-matching, even if the laboratory has dispositioned a profile as a hit. Any state manuals regarding the use of SDIS and NDIS database, any hits made to any profile uploaded, even if they hit on individuals not the defendant and deemed to not be candidate matches, including hits to any unknown males identified during testing. The state has provided information related to this request for the DNA on the snap of the knife sheath only. The defense has requested all profiles, including additional ones developed during the course of the investigation. See declarations of counsel for Mr. Kohberger, Bicca Barlow, and Steve Mercer, filed simultaneously. Who are they? Communications. Please provide a copy of all communications between the personnel of the lab. Unexpected results and corrective actions. Genetic genealogy test and search. They want all the reports. The whole way they got. Basically, they were asking for everything. And I don't know if that is common. But if he has, access to his discovery, I mean, this is all he has to do. And I don't think we're going to see a trial this year. I really don't. The state has objected to sharing all of the names in this request. Further, the state has filed a motion for a protective order. Mr. Kohberger incorporates herein his objection to the state's motion for a protective order, as well as declarations of counsel for Mr. Kohberger, Bicca Barlow, and Steve Mercer in support of defendant's motion to compel.
Cut his mic. Cut his mic.
Notice of filing. All right, we're going to find out who Bicca Barlow is. Good morning, Michelle. Good to see you this morning. Bicca Barlow. Bicca Barlow might be related to Roro and Pawpaw.
Roro causing Pawpaw. I mean, that's
Roro. Who was Roro?
Who is Bicca? Who is Bicca? Bicca. Brian Kohberger is coming through his attorney and Taylor and hereby files the attached declaration of Bicca Barlow in support of defendant's third motion to compel. These must be the experts. I, Bicca Barlow, do state and declare I am an attorney licensed to practice in the law in the state of California, and I have been retained to assist counsel for Brian Kohberger in the above matter in the capacity of DNA consultant. I have a BS from the University of California, Berkeley in genetics and an MS from Cornell University in developmental genetics with minors in cellular biology and plant molecular biology. I received my JD from the University of San Francisco School of Law. I began consulting on DNA cases as a law student in 94. In 2004, I was hired as the DNA attorney for the San Francisco Public Defender's Office. He's getting the best of the best. During my 9 years at the office, my practice was focused almost completely on DNA cases. During my 9 years at the office, my practice was focused almost completely on DNA. I already read that. 2013, I left the office and returned to consulting on DNA throughout the U.S. and in both state and federal courts. I have acted as a DNA counsel or as a consultant on cases involving DNA evidence in over 200 cases, including capital cases. Additionally, I have retained in 3 cases as a Strickland expert to assess the performance of trial counsel as it related to DNA evidence. As DNA counsel, I have reviewed case files for DNA evidence from many labs throughout California and the United States. And then she goes on to list all of those labs. I regularly communicate with attorneys and experts who specialize in DNA evidence. I also regularly train attorneys in the area of DNA evidence. I was requested by counsel in this case to assist in determining the scope of DNA discovery necessary for defending this case, including any genetic genealogy that was used. Part of this assignment was to identify potential expert witnesses and legal issues that might arise from the use of genetic genealogy. Because I have been retained on other cases involving genetic genealogy, I am aware of the methods used and the type of material that is, and has been made available in criminal cases. In order to assist counsel in this and other cases, I have reviewed a multitude of materials, including peer-reviewed articles, magazines, and newspaper articles and motions. I have also interviewed numerous expert witnesses in order to identify potential areas of interest to the defense. I don't know how they can have any mistakes in this day and age in any documents whatsoever. I mean, you type in any kind of word processor and it corrects it or it underlines it. I don't get these people. Pay attention to details. It's important. I have reviewed the material provided to the defense in this case regarding the DNA testing done, as well as numerous news articles regarding this case and the government's motion for protective order filed on June 16, 2023. I am informed and believe via news reports that in this case, Mr. Kohberger was initially identified as a possible suspect via a new methodology called investigative or forensic genetic genealogy. And it would therefore be called IgG. Absolutely, he deserves the best of the best because there needs to be no room for error. Once this guy is behind bars, he needs to stay behind bars. I am familiar with the methods used to conduct IgG searches. I have been retained in other jurisdictions on cases involving this type of search and have oh my gosh. Coffee time. When I'm tongue-tied, I need some coffee. I have received and reviewed reports generated by the private company that conducted both the testing itself and the construction of the family tree that led to the ID of the defendant. Based on my review, I am informed and believe that the use of these databases did not necessarily lead to a single individual. The testing is different in a private lab from forensic labs. And then she goes on to explain the same thing Kohberger said earlier. I'm aware. Okay, wait. GED Match has recently been acquired by Verogen Labs. I am aware of only one other website that allows law enforcement searches. Most websites, such as 23andMe, do not allow use of their data by law enforcement, are used by most people for ancestry research. Okay, but didn't they say in that other motion that they didn't do it in a forensic way, that they did it in a non-traditional, like the traditional way that a normal person would? Do you know what I mean? Like, we got to go back in that after this one. Because I think they said the FBI like took the sample from Othram and they did their own family tree like the same way that normal people would if they went on any of these sites. I don't think it was done the way that this person's describing from what I remember reading. But you guys, I haven't seen anybody comment on that. Curious, because that's what I understood, was that Othram never actually touched it. But maybe I read that wrong. We'll go back and look. Data is compared within that database and possible relatives are identified. The determination of who is or who is not a relative is subjective and based on the length of DNA shared between the two individuals. I thought so too, Jammers. She said, that's what I recall. We'll go back and we'll double check it. The comparisons in such a database do not yield an ID of someone identical. The uploaded SMP data, rather it would identify possible relatives. Once a putative relative has been identified, a family tree is created, working backwards to grandparents and possible great-great-grandparents. The family tree is then built down. Yeah, they went through how they got this. It says, difficulties with tracing a family tree may arise when there are events that sever a relationship, such as an out-of-wedlock birth, name change, or adoption. See, this is where it gets interesting, because I know some of us think that he could possibly not be the bio son of that dad. I've heard that on multiple occasions. If that were the case, and I don't know, maybe he's just trying to create some doubt here, but if that were the case, then where do we stand? We were talking about this last night. I was like, then Daddy Kohberger's got a problem. So if it ends up that they're like, no, can't be him because he was adopted or, he was born out of wedlock to someone else. Like, I don't know. In some instances, contacting individuals for further family information, such as noted above. This process leads to a pool of individuals rather than one specific individual. I am also aware via news reports in the Golden State Killer case that multiple individuals are often identified and must be eliminated in order to find the potential suspect, as described in the Washington Post. The technique leads to a pool of relatives, not a single individual. And then they reference other cases, Angie Dodge, in the episode from the Genetic Detective Show, Who Killed Angie Dodge? At least one relative of the defendant in that case was investigated and ruled out. Further complicating the Dodge case was the fact that the defendant in the case had been born after his parents' divorce and adopted by his stepfather. See this? Yeah, I mean, he could just be trying to put doubt in there. Who knows? In addition, there has been a history of misuse of these IgG databases by law enforcement. Video history regarding law enforcement use of GED match. It's a YouTube video. Is it this? Is this it? Stop. That can't be it. There Jay goes Googling again. Stay off the Googles. And here's another misspelled word. Viztide. I don't understand the lack of spelling correctly. I mean, that should be a given. Viztide. While in the Dodge case, another relative was ruled out. It is unknown to the defense in this case whether every lead or possible suspect was further investigated and ruled out by genetic testing. Because the family trees generated by these genealogy searches often identify distant relatives through great or great-great-grandparents, a person may be completely unaware of the relatives in the genetic genealogy searches and unable to conduct an independent investigation of possible third-party suspects. It is not possible for any defendant to investigate family relatives who are unknown to him and may in fact have been in the area of the crime. This material is clearly Brady material in that it would provide investigative leads that are otherwise unavailable to Mr. Kohberger. Bringing up Brady, knowing that the Moscow have, the couple of those officers have Brady violations. So they go on talking about the pool, This is all case reference. Let's see. From the discovery in this case, it appears that at least 3. Okay, here we go. From the discovery in this case, it appears that at least 3 and possibly 4 profiles were uploaded to CODIS prior to Mr. Kohberger being charged. 3, possibly 4. So he has something that shows that there might be other people or other, I shouldn't say other people, other DNA profiles. If he knows that there's 3, possibly 4, what exactly does he have and not have is my question. Because he knows of the existence, right? He knows of the existence of 3, possibly 4. So what's he wanting from these is everybody's names. He wants their names and addresses and phone numbers of all the grand jurors, all the people in the DNA profile thing. They don't give that out. And of course, they're going to test other DNA. They're going to test a whole lot of DNA at a scene. If they don't have a suspect, they're going to be testing DNA and they're going to be matching it and they're going to be ruling people out. So what they do, and we went over this in a prior video, they literally start from the inside out. They start with the immediate circle. So you can bet your ass they started with Bethany and Dylan and Jack D and Adam and all their friends, all their close friends that they hung out with. Then they went to Hoodie Guy. Then they went to people a little bit more outside that circle. Classmates, old, sorority sisters, questioning neighbors, people who didn't know them but might have seen them. I mean, you've got to remember that there's going to be more than just the killer's DNA in this house. Okay, here she says, in the last 10 years of my practice, I have encountered a number of cases in which a database search has resulted in more than one candidate and in which, upon court order, the anonymous profiles of the other non-matching profiles have been provided to the defense under court order. The number of non-matching profiles varies from case to case and include one case in Santa Clara County. In Hernandez, the lab uploaded multiple interpretations of a mixed sample to the state's database. One interpretation returned 5 candidates, and the second returned 28, including the defendant. In Hernandez, the lab opined that 2 of the candidates could not be excluded as a source, while a defense expert reached a different opinion that 15 of the candidates could not be excluded. The lab in the Hernandez case provided to the defendant the profiles of the 5 and 28 individuals from the CODIS search. This information was presented at trial in order to impeach the interpretation of the work done by the lab and to undermine the idea that a match by a lab is an actual identification of a single individual. The fact of this match made by the CODIS system is considered Brady material because it provides possible avenues of investigation of other suspects in this case. Given the subjective nature of mixture interpretation, it is reasonable to believe that other experts might disagree with whom is actually the candidate. And in this case, in which the profile at issue is ambiguous and partial, other suspects are an important area of investigation. Okay, let's break this information down just for a second. I just want to talk this through because we had Brian Kohberger back in late December when he was arrested saying, I can't wait to get back to Idaho so I can be exonerated. What happened to the exoneration, Mr. Kohberger? Where's the alibi, Mr. Kohberger? I see a bunch of distractions, Mr. Kohberger. Do you guys not see just a bunch of distractions? Detra Ed. Most killers with motives know their victims. It depends on what you consider knowing your victims. Because I feel like a killer can feel like he knows a victim and the victim may not even know who the hell it is. You get what I'm saying? He could have felt like he knew these girls. Someone watching girls on social media and watching their videos and watching their everyday life, they feel like they know them. That is the danger of young girls putting all of this stuff on social media, is that there's weirdos who are socially inept, who can't form normal relationships with the opposite sex. So they have more guts behind an app. And they might communicate with them in comments and shit like that. But they feel like they know them. It doesn't mean that the victims knew him. He may have felt like he knew them. And if he was watching them, he definitely would feel that way because he would know their every move. He would know their daily life. Yeah, it's sick. Hey, Potato. Welcome. Hope you had a good day at work. Okay, and then it says laboratories are under accreditation standards to maintain logs, and they want those logs. And now San Francisco, California, Bicca Barlow. But it says here that she signed this in 2020. So I don't know, like Bicca, you spelled a lot of things wrong. And you dated your final comment dated in 2020. Is this real? Is this done on purpose? What kind of expert makes these kinds of mistakes? She's 3 years in the past. Call her Michael J. Fox because she's back to the fucking future. What is she doing? $2020? Y'all are like, oh, who cares if she wrote Brian Kohberger like he's a hamburger? Well, now we have this 2020. Hello.
Papa. Roro causing Papa. I mean, that's
Roro.
not-
Who was Roro?
I mean, what? Explain this to me, though. Right. I mean, it shows the level of professionalism. I agree, Dr. Melmo. 2020? Get this girl a skateboard. She's Michael J. Fox in Back to the Future. Oh, shit. You can't make it up. And here she's got her resume after. She dates it 2020. Bicca Barlow. She made sure that her header was on each one. Inside the cell, the dark side of forensic DNA. She has this as an exhibit. Dangers of the database, cold hits and coincidental matches. So she literally took pictures of this book and put it in his exhibits. And I'm not reading this book, but I will put the link in the description if you guys want to go through and read everything that they're putting in. You guys think it was copy and paste from a prior case? That's pretty sloppy, isn't it? It's not fair to the accused to read the documents and analyze them? Wow. Okay, I guess I should just shut up then. I mean, what's the point of reading the documents if you're not going to talk about them? And why are you so defensive of Brian Kohberger? Yikes, Ashley. It's kind of scary.
Brian Kohberger.
I mean, this dude's in jail, like, for a reason. He's not there because he wasn't involved. Come on now. Come on now. Are you kidding?
Wake up.
Okay, on to the next one. We have a lot. Order denying the associated... Oh, wait. No. Hold on. Order reserving ruling on the issue of cameras in the courtroom. Here we go. Say cheese. Say cheese.
Because you're a liar.
On May 1st, 2023, a coalition of 20 media outlets filed a motion to intervene and a motion to vacate the amended non-dissemination order at a scheduling conference conducted on May 22nd. And the judge took a full month to rule on this. The court asked the parties and the Associated Press to brief the issue. An oral argument was heard June 9th. The state was represented by William Thompson, Bradley Rudley, and Brian. Kohberger was represented by Ann Taylor and Jay Logsdon. The Associated Press was represented by Wendy Olson and Corey Caroni. Given the high-profile nature of this case, the public's interest in watching what is happening in the courtroom, and Kohberger's fundamental right to a fair trial by an impartial jury, the court will reserve ruling on the issues of cameras in the courtroom. The court is faced with a difficult task of ensuring the proceedings are open to the public while also safeguarding Kohberger's right to a fair trial. The best way to continue to balance those interests is to revisit the issue of cameras in the courtroom as the case unfolds. This court has discretion to either allow or disallow video recording of the proceedings. For now, cameras in the courtroom will continue to be allowed. So we will have video of the 27th hearing. However, that is subject to change by further notice of this court. My Caroni. So cameras stay, guys, as of now. So on the 27th, we will have a recorder. They'll do the same thing like they did before, where they go in, the pool camera records it, and then afterwards they upload it and we all get it. So we'll be able to see it after it concludes, which is pretty cool. I'm glad he's doing that for now anyways. Now we're going to go to the order denying the Associated Press's motion. Or is it the 26th or 27th? I thought it was the 27th. Is it the 26th? Is it Monday or Tuesday? All right. So this order addresses the motion to vacate the amended non-dissemination order filed by the media. Let's go into this. The Associated Press motion to vacate the amended non-dissemination order is denied. This court has the authority to regulate the speech of attorneys participating in this case and the agents for those attorneys to ensure that Kohberger is not denied his right to a fair trial by an impartial jury. However, this court will issue a revised, amended non-dissemination order that clarifies. Finally, hooray! We're getting clarification, right? Finally. That's what we've wanted. We've wanted clarification. That's what Shannon Gray has been saying all along. I just want clarification. What can we talk about? What can we not talk about? Because we don't want to get in trouble. We don't want to, damage the case. The revised amended non-dissemination order is reasonable considering the facts of this case. 1, the evidence presented by the defense showing the pervasiveness of media coverage, including coverage prejudicial to Kohberger and coverage that includes extrajudicial statements by an attorney participating in the case, and 2, the impact of the news coverage on potential jurors and the fair administration of justice. Then it goes into the background. It says that the cause of death for each was ruled a homicide. As news of the tragedy broke, media outlets from around the country descended upon Moscow. As law enforcement investigated, news stations, newspapers, and social media were flooded with stories and speculation about the homicides. Throughout the course of the investigation, the Moscow Police Department, in partnership with the University of Idaho, Latah County prosecutors, and the Idaho State Police, held briefings to answer questions and assure the public. Appropriately, the information released was limited to protect the integrity of the ongoing investigation. On December 30th, Kohberger was arrested and charged with 4 counts of murder. Again, and 1 count of burglary. Again, media outlets descended upon Moscow and news coverage quickly focused on Kohberger. And then it goes through. They had hearings on this and blah, blah, blah. Okay. So here we go. This is the amended non-dissemination order. So this is the changes as of now. Okay. It is hereby ordered 1, the attorneys for any interested party in this case, including the prosecuting attorney, defense, and any attorney representing a witness, victim, or victim's family, as well as the parties to the above entitled action, including but not limited to investigators, law enforcement, and agents for the prosecuting attorney or defense attorney. They are prohibited from making written or oral statements concerning this case, except without additional comment, a quotation from, or reference to the official public record. So they can talk about anything that's in public record. Number 2, this order specifically prohibits any statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. A, evidence regarding the occurrences or transactions involved in this case. B, A, evidence regarding the occurrences or transactions involved in this case. Is transactions a regular legal word, I wonder, that they put in here? The character, credibility, reputation, or criminal records of a party, victim, or witness, or the identity of a witness, or the expected testimony of a party, victim, or witness. The performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test. Any person as to the merits of the case or the claims or defense of a party. Any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a risk of an impartial trial. Any information reasonably likely to interfere with a fair trial in this case afforded under the U.S. and Idaho Constitution, such as the existence or contents of any confession, admission, or statement given by the defendant, the possibility of a plea of guilt, or any opinion as to the defendant's guilt or innocence. So they can talk about anything that's public record, official, and they cannot talk about Brian Kohberger's guilt or innocence. On February 6, 2023, the Associated Press filed a petition for writ of mandamus or a writ of prohibition with the Supreme Court. The Supreme Court found that the media did have a standing to challenge the amended non-dissemination, but they first must present to the trial court. So that's what they did. And then on May 16th, an indictment was filed against Kohberger, and this court began presiding over the case. On May 22nd, after Kohberger's arraignment, this court conducted a scheduling conference and set a briefing schedule and hearing for oral argument. The Associated Press's motion to vacate was extensively briefed, and both the state and Kohberger submitted extensive briefing in opposition to the motion. Oral argument was heard on June 9th. During the hearing, the defense put on testimony of 2 expert witnesses. First, this is the hearing we didn't hear. First, Jean R. Saucier, Senior Vice President of TrueScope, testified. In sum, Ms. Saucier testified to the quantity of media coverage in this case. It is undisputed that media coverage in this case is rampant and ongoing, including on television, the internet, social media, and radio. News surrounding the case is being reported by reliable sources of news, unreliable news outlets, and individuals engaging in spreading or fueling rumors, theories, and unfounded speculation. So true. It's true. It is also worth noting that Ms. Saucier's testimony and the exhibits she showed demonstrated that in the share of voice media coverage category, Shannon Gray's stories in the media had the highest potential reach. At 561,102,573 impressions. Do you know how angry that must make Brian C. Kohberger?
Okay.
Do you know?
Brian Kohberger. You know what I have to say to Ann C. Taylor, the defense lawyer?
Bring it on,
woman.
Speaking of this kind of stuff, spreading or fueling rumors, theories, and unfounded speculation. I want to talk for a second. Let's talk for a second. Okay. Take a little pause. This is still going on. Okay. I saw a YouTube video last night where someone was trying to disseminate false information, but in turn was reading something about Xana's injuries, body parts being cut off. If you believe this kind of shit to be fake, don't repeat it for the world to hear. That's what spreading, fueling rumors is. If you think it's true, if you think it's not true, and you think someone coming forward saying they have inside information and all this and that, and you want to prove them wrong, don't read their shit. That goes against the whole point of it. The Associated Press argued that the amended non-dissemination order restrains their constitutional right to gather news before it can be exercised. Okay, so this decision addresses the following. 1, the obligation of the court to ensure that he has a fair trial. 2, the court's authority to impose restrictions on the speech of those attorneys and their agents. And 3, the standard applied to reviewing constitutional challenges by the media to non-dissemination orders aimed at trial participants, especially lawyers. Yeah, William Mitchell, like, we're not doing that. Now, why would you do that? Don't do it again. Don't do it again. Don't name anybody. I'm not here to name anyone. We're not doing that. And we're not saying what was in it, William Mitchell. You clearly know that I just said that because I didn't appreciate that information. So then you put it in my chat. So you've been timed out, dude. If you can be cool and come back, that's awesome. If not, I don't know what to tell you. All right, because I keep this here for people who want to focus on the facts, and that's what we're reading. We're reading facts. In summary, the court stated that the trial court might well have prescribed. Let's see. I'm not reading all of this. Anyways, they denied the non-dissemination. So the judge basically amended it to be clear. I mean, that's what Shannon Gray was asking. What is the clarification on this? Now we have an order denying Shannon Gray's request. Okay, so order denying Shannon Gray's request to be exempt from the amended order. At the outset, the court would like to make clear that the amended non-dissemination order does not restrict the Gonsalves family from speaking about the case to the media or anyone else. Instead, the order restricts attorneys for the parties, attorneys representing victims' families, and attorneys representing witnesses from speaking out about the case. Gray's motion asks this court to exempt him from any regulation on his ability to speak to the media and the public, or at least to clarify the amended non-dissemination order. In deciding the motion, the court must balance Gray's First Amendment rights against Brian Kohberger, right to a fair trial by an impartial jury. Gray's request to be exempted from the amended non-dissemination order is denied. However, the court will issue a revised amended non-dissemination order that clarifies what can be discussed and what cannot. And then it says that it's limited to apply only to speech that is substantially likely to have a materially prejudicial effect on the right to a fair trial. It applies equally to all attorneys in the case. It is neutral as to the points of view, and it limits Gray's restricted comments only until after the trial and any sentencing proceedings that may take place. The regulation on Gray's speech is narrowly tailored to balance the competing interests of the First Amendment and the Sixth Amendment. Crystal says the facts are there are others. And if there are others, then take a deep breath and wait for the response from the state. Hey, Agape. Hey, Mark Klein. But yeah, even if what Mitchell put in the chat was true, I still wouldn't allow it. Because that's somebody's sister, that's somebody's daughter, that's somebody's niece, and that's somebody's friend. And if you don't respect those four titles of someone who was brutally snuffed out of this life at a young age, then I have no need for you here. You're at the wrong fucking channel. That's all I got to say. Because the victims who are deceased here trump Brian C. Kohberger in my book every day of the week. I want him to have a fair trial. I want him to be put away forever if he did this. But I do not want victims put out there and you know, exploited. Not in my house. Not in my house. So Gray was denied. All right, next one. Jeez, Pete, we've got 1, 2, 3, 4 more. Revised amended non-dissemination order. As discussed in detail in this court order denying Shannon Gray's request to be exempt from the non-dissemination order and granting requests that the order be clarified. And this court's order denying the Associated Press's motion to vacate, the court must attempt to balance the Sixth Amendment and the First Amendment. To preserve the right to a fair trial, some curtailment of the dissemination of information is necessary. Therefore, the following is ordered. 1. The prosecuting attorneys, defense attorneys, any agents, defense attorneys, any agents, witnesses, victim's family, they cannot make any extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know would have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. This order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated. We've read through those, didn't we? Is it the same thing? We'll read through it again. A, the identity or nature of evidence expected to be presented at trial. No, this is different. This is for Shannon Gray. The identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. Any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. The character, credibility, reputation, or criminal record of a party, victim, or witness. The identity of a witness. Detra Ed, you can't make a decision today because we don't have all the evidence. You can't. The performance or results of any examination or test or the refusal or failure of the defendant or a witness to submit to an examination or test an opinion as to the guilt or innocence of the defendant, the possibility of a plea of guilty to the offenses or any comment on any plea discussions, the existence of or contents of any confession, admission, or statement by the defendant, or the refusal of the defendant to make any statement, any information obtained by witnesses, the victim's families, or their attorneys from the state that is confidential. Attorneys involved in the case and their agents, as outlined in paragraph 1, may make extrajudicial statements, written or oral, concerning the following. So they can talk about the claim, offense, or defense involved, and, except when prohibited by law, the identity of the parties involved. I think that's what they mean. Information contained in the public record, that an investigation is ongoing, and that the scheduling or result of any step in the litigation, a request for assistance from the public in obtaining evidence and information necessary to the state's case or the defense's case, so they can ask. They're saying they can still ask for help from the public. Hence, the Gonsalves's Facebook. A warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. The identity. Wait, they can talk about all that? Yeah, okay. They can talk about the identity, residence, occupation, and family status of the accused. They can talk about the fact, time, and place of arrest, the identity of investigating and arresting officers or agencies, and the length of the investigation. Dude, Shannon Gray can talk about a lot. A statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue, prejudicial effect of recent publicity not initiated by a lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. No individual covered by this revised amendment non-dissemination order shall deliberately avoid its proscriptions by actions directly or indirectly that result in violating this order. This revised amended non-dissemination order shall remain in full force and effect until the conclusion of a trial and any sentencing proceedings that may follow unless otherwise ordered by this court. And John Judge got it right. He got the year right, 2023. Hello, Miss Potts. She says, good morning, Jay. I'm not here to troll, I swear. That's good, because if you are, you'll probably end up blocked by one of our lovely moderators. Welcome, Miss Potts. All right, so we have motion to file defense counsel's first sworn statement of facts in support of motion to stay proceedings. So if you remember the last hearing, or not the last hearing, the last batch of documents we went through, they said you have to provide a statement of facts in order to get a stay. So, like, provide this statement of facts, and then the judge will decide. He was putting the cart before the horse. Remember that? So that's what this is about. Comes now Brian C. Kohberger.
Brian Kohberger.
By and through his attorney, Ann C. Taylor, public defender, hereby moves the court for an order to file defense counsel's first sworn statement. Under seal. We don't get to see that exhibit. They always challenge DNA.
Exhibit EXHIBITY.
Everything they're doing is for, it's all procedural. They have to do all this. They have to look at all the people that they had DNA matches on. They've got to. Order granting motion to intervene for limited purposes. Okay. On May 1st, a coalition of 20 media outlets filed a motion to intervene and a motion to vacate the non-dissemination order. Oral argument was heard on June 9th. The parties had no objection to the motion to intervene for the limited purpose of challenging the amended non-dissemination. Thus, the motion to intervene is granted for the limited purpose of allowing the Associated Press to challenge the amended non-dissemination order. And then we have the order granting motion to take judicial notice of press coverage. On May 1st, a coalition of 20 media outlets filed a motion to intervene and a motion to vacate the non-dissemination order. Brian C. Kohberger, in turn, filed a motion to take judicial notice of press coverage. Oral argument was heard on June 9th. For the reasons articulated on the record, defendant's motion to take judicial notice of press coverage is granted. Defendant's motion to take judicial notice of press coverage is granted. Signed by John Judge, June 23rd. And that is all of them, but we're going to go back because I want to see what their description was of the way that they made that family tree and all of that. So let's go back up here, find it. It would have been state's motion for protective order, state's response to request for discovery, maybe? Nope. There's so many. I thought it was the fourth. It's really a long one. Which one was it called? State's objection to motion, no. State's motion for protective order, no. So I wonder what his statement of facts is for him being able to stay the case and if the judge will approve it or deny it. Okay, it's got to be after this then. Defendant's fourth motion, state's motion. I think this might be it. Damn. Do you guys remember what it was called? Potato, do you remember which one it was where they went into detail about the... DNA. I know you guys think that the state is hiding stuff, but hey, I mean, they're asking for it, so it'll probably be put out there. They've gotten a lot of stuff, though. Like they're saying, oh, we haven't gotten this, but it seems like a lot of it is semantics. That's the grand jury. Thanks, Potato. Forensic genealogy for criminal cases is fascinating, says Just Joe. Solving cases everywhere. Were people planning DNA before DNA was a thing, like the 80s? Nope. I know it's in there, Dinks. Dinks, which one is it? I'm waiting for Potato to tell me the name of it. We just read it last week. They always look to dismiss. Thank you, Potato. It's a 616 one. Okay. Defendants, state's motion for protective order. Let's see. What's this one? That's not it. We'll just click everyone on the 16th. You're welcome, Just Joe. Yep, here it is. Thank you, Potato. Thank you, Potato.
I flashed and said, wow, pretty far out.
I thought it was pretty far out. Okay, so this is describing how they went about getting this DNA. And we're going to read through this again. Just because this order we just read said that the private lab did the family tree. And I'm telling you, we read this and the FBI did it. So I don't understand these filings. So let's look back through, because Jammers backed me up on this. Jammers was like, I remember hearing that too. She's like, I remember hearing that too. 33 pages. You're welcome, darling.
Fucking fuzzy slippers and lip gloss.
Oh, guys. Okay. We're going to look through this. On November 13th, 2022, law enforcement found the bodies of Maddie, Kaylee, Xana, and Ethan. All four died from apparent knife wounds. Law enforcement found a K-bar knife sheath on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under both Madison's body and the comforter on the bed. The Idaho State Police in Meridian, Idaho, located the DNA. Okay, so let's get that down. The ISP lab located the DNA on the sheath. The ISP lab determined the DNA came from a single source and that the source was male. Now, this is just about the sheath. This isn't about the other DNA found, whatever. Once law enforcement had a single source DNA, they conducted what is called an STR, a short tandem repeat analysis. STR DNA analysis involves looking at 20 regions within human DNA and allows law enforcement to make a direct comparison between two STR DNA profiles. Law enforcement submitted the STR DNA profile obtained from the K-bar knife sheath to the combined DNA system, CODIS. No match was found. So they got a single source of DNA from the button. They threw it into CODIS, and they did not get a match. They didn't say they saw the knife sheath from the doorway. They said they saw it when they looked again. So that would have been probably when the coroner arrived and moved the comforter, because police were not allowed to touch the bodies. Unable to find a match using STR DNA analysis, law enforcement decided to use investigative genetic genealogy to find a lead. Genetic genealogy allows individuals to trace their lineage or connect with unknown family members using DNA. Typically, it involves sending a DNA sample, such as a tube of saliva, to a genetic genealogy service like Ancestry and 23andMe. An SMP profile is different than an STR profile and is used more often for genealogical purposes, and there's a footnote. We'll read that when we get down there. The genetic genealogy service then uses an algorithm to compare the user's SNP to existing SNP profiles. Well, on the second attempt, maybe that's when the coroner was there and that's when they were able to see it. Maybe the cop was in the doorway while the coroner was tending to the bodies, and that's why it says he saw it from a doorway on a second look. I mean, all these things can be explained if you just take a step back and don't jump to conclusions. The genetic genealogy service then uses an algorithm. I read that. The same process used by members of the public can be used by law enforcement as part of their investigation, a technique referred to as investigative genetic genealogy, or IGG. Once a publicly available genetic genealogy service shows law enforcement potential relatives of the suspect, law enforcement applies traditional investigative and genealogical methods to build a family tree in an effort to follow the tree to the suspect or a close relative of the suspect. None of this even fucking matters because they took a buccal swab of Brian Kohberger's cheek. That trumps the garbage that they took. I guess, Dinky, they should just let the suspect run free in your world. Until they can prove he did it, let him run free, because God forbid Brian Kohberger is behind bars.
Oh my God. God forbid.
You call it jumping to conclusions to talk about a suspect that has been arrested and that has DNA linking him to the crime scene? You think that's jumping to a conclusion, or is that talking about the facts? Because that is the facts, Jack. His DNA was on the button. His DNA matched his cheek to the button. That's not jumping to a conclusion. That is facts.
La, 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 la. You don't hold account.
Family trees can be used to narrow down a potential suspect based on age, gender, opportunity, known physical characteristics of the suspect, etc. In this case, investigators used IGG to begin the process of developing a lead to the individual who left DNA on the K-bar knife sheath. The Idaho State Police utilized a private lab to develop an SNP profile. Okay, so here we go with the private lab. The private lab started using genetic genealogy to develop a family tree. Here we go. They started to. The private lab started using genetic genealogy to develop a family tree, but after law enforcement decided the FBI would take over, the private lab ceased its efforts and sent the SNP profile to the FBI. Okay, it may have been a lead, Mary, but it's right here in black and white. They sent it to the FBI. The FBI uploaded the SNP profile that was made by this private lab. So that's what they have a problem with. The Idaho State Police utilizing this private lab to get the profile. Fine. They said in the Washington thing they didn't even need the DNA in order to search his apartment. And that was before they had a buccal swab. I guess, Detra Ed, my question to you would be, if you aren't interested until everything comes out in a trial, why are you even following right now? Why aren't you waiting until the trial? I don't get it. And I didn't see anything in those things we read where it was anything about a comforter. So did I miss that? Because someone said, oh, they name where it was at. Let's go down to this footnote here. Number 2. For ease of reference, this motion focuses on the FBI's IGG efforts. The state is also seeking to protect the partial family tree created by the private lab, and it should be protected for the same reasons the FBI's IGG efforts should be protected. This is going to be up to the judge, guys. If the judge decides that it should be private or not. And I don't know if it should be or not. I say give them everything. Why not? What's it going to hurt? If they have a good case, then they should be handing it over unless it's going to be used to intimidate potential witnesses. So let's say, for example, and what I mean by that is, let's think about Jack D. He was probably suspect number 1. You can bet your ass that they interrogated Jack D. Probably from day 1. Candy Girl says, can't come to any conclusions until the trial. This is just entertainment. See, I don't find the deaths of 4 college students entertaining by any stretch of the imagination. I guess that's where I'm different than a lot of people, because I don't find false statements by some lady that says her name is Kim WSU to be entertaining. Talking about Xana's body parts being cut off. I don't find that entertainment. So that's where I'm different. If you find that entertaining and find these crimes entertaining, I'm not on the same page as you. I just have a different view on these cases. I don't look at these people as entertainment. I look at them as people, and I look at their parents as people that are grieving and stuff. And I don't look at it that way. I don't look at these documents being released as, yay, it's entertainment. AF, I guess we'll see, won't we? As fuck. I guess we're going to see as fuck. We're going to see if I am off base. Because you're going to need... You need more slaw in a second. I'm glad you came in here, AF, as fuck. You are so off as fuck. Eyebrows on fleek as fuck. Oh, shit. It's called interesting. Yes, absolutely. It's interesting. It's absolutely interesting. TV is entertainment, says Candy Girl. Brian is also people. I'm not worried about Brian. Brian's got the best defense that Brian can have. I'm not going to be sitting here losing sleep over Brian C. Kohberger. But I will lose sleep about compromising information about dead 20-year-olds. Yes, ma'am. As fuck. What about the 3 unidentified DNA as fuck found by the victims' bodies? I don't know. Maybe they had sex with their boyfriend. And maybe their boyfriend's DNA is on their bed. Ooh, imagine that. Imagine that. Watching YouTubers is entertainment, not the death of 4 people. Okay, I get that, Candy Girl. Watching is entertaining, but these people aren't your entertainment. Bye, AF. People get beat up if we question other suspects. You don't have the right to question other suspects. You're not the investigator. So you don't get to question people that are presumed innocent right here, that have not been charged with a crime, that are not incarcerated. And we are a learning community, Mary. I'm not going to put up with victims being talked about like that here. It's unknown male DNA that was never tested by law enforcement. You don't know if they tested it. The defense doesn't have the reports. How would you know if they tested it? How do you know that? See, that's what I mean. You're stating facts that aren't facts. Oh, shit. Well, I think that we can all agree to disagree without being assholes, right? I mean, we can definitely do that. I think that's what being an adult is all about, is agreeing to disagree. Where, Mary P., what document is the comforter? Which, the prosecution discovery? Okay, thank you, Miss Potts. I'm not a lawyer. I'm just reading what's in black and white, you guys. The person who tells me I have a foul mouth has their name AF. Oh, man. Okay, so it's Trixie. Thank you. Trixie, the voice of reason. Oh, my God. Where is the evidence that the house was a trap house? This is not a cover up. They released some facts on who is guilty. Now it's up to the court to prove their case. Absolutely. I mean, you guys, which one is it? Right, Harlot Oscara. Of course they tested all the DNA. They're not going to just collect samples of DNA and not test them. Hey, Patrick. I'm looking for the document that mentions specifically Maddie's comforter. There was 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 things filed yesterday. Which one is it? Dave's not here, man. Ann Taylor says, Samantha Berry. Ann Taylor's being paid to try and poke holes. It's her job. Right. I'm just looking for the document that mentions, someone said that her Maddie's comforter is mentioned and I didn't see it. So I'm asking what document Maddie's comforter is mentioned in, because I want to read it. Zinc Floyd. Hello. Yeah, there's a cat. She's outside. Is the document referred to as factual background? Is it One Maiden Nut? We have defendant's motion to shorten time. And welcome, Zinc Floyd, to the chat. Thanks for making yourself known. Notice of hearing defendant's third motion to compel, order reserving ruling on the court. Okay, order. Revised, amended non-dissemination. Motion to file defense counsel's first sworn statement. That one? Nope. That's not it either. Where is it even mentioned? Lola Bean. I have never heard of a drug hit with a knife. It's always guns and they never leave witnesses, but I don't know. No, you're right. That's usually how it goes, Lola Bean. Yvonne, how do they know it's unknown if it wasn't tested? Well, it's unknown to the defense because they didn't get the records. Damned Schizo. It's the prosecution response to defense where her blanket was mentioned. Thank you, Schizo. Prosecution response to defense. State's response to the fourth. Nope. Amended. Nope. Is it filed by the state or the defendant? I didn't read anything about her comforter. One made nut. Is it objection to state's motion for a protective order? Let me look. Thanks, dude. Objection to state's motion for a protective order. Here's the state's motion for protective order, and then the objection is where? I think I found it. Thank you, Eddie. Eddie, what have you done for me lately? You just helped me, Eddie.
Eddie, what have you done for me lately?
Come on, my three sons. You're smarter than that. Pushing the envelope, I tell you. All right, we're going to read this factual background. On November 13th, 2022, law enforcement responding to a 911 call found Madison Mogan, Kaylee Gonsalves, Xander Kernodle, and Ethan Chapin deceased. Law enforcement later found a K-bar knife sheath placed next to Miss Mogan on her bed. Placed? Wait, this is Brian Kohberger's. This is Brian Kohberger's thing. Placed next to Miss Mogan. Not dropped by accident. He's insinuating that it was put there on purpose in this document. And we don't know that, but he's putting the word placed. Law enforcement later found a K-bar knife sheath placed next to Miss Mogan on her bed. The sheath was placed button side down and partially under Miss Mogan and the comforter. So he's saying that somebody put it underneath Maddie and then covered it up with the comforter. Hey, Jay Leal, good morning. We are way hours in. We are at the end. On November 20th, 2022, the Idaho State Police Lab in Meridian, Idaho, located DNA on the button of the sheath and performed STR analysis that led nowhere when running through CODIS, other than to show the provider was a male. By December 17th, lab analysts were aware of 2 additional males' DNA within the house where the deceased were located, and another unknown male DNA on a glove found outside the residence on November 20th, 2022. So what I heard was that was one of the law enforcement personnel's gloves that was dropped and found. And unknown male DNA in the house. 2 additional males' DNA. Okay, well, we know Ethan's a male, and Ethan was there. And we know that there were several males there. I mean, we saw tons of males in that house. So, I don't know, man. To this date, the defense is unaware of what sort of testing, if any, was conducted on these samples other than the STR profiles. Further, these 3 separate and distinct DNA profiles were not identified through CODIS, leading to the conclusion that the profiles do not belong to Mr. Kohberger. So they don't even know if this DNA is Kohberger's or not. And I think this is Brian Kohberger wanting her to file these. I don't think this is her saying this is going to be your best route of defense. In some of these, anyways. In some of these, I think this is him pushing for it, and she has to do what he wants. While this was ongoing, police were investigating many various possible suspects. Many of them provided DNA. I mean, hell, Jeremy spoke in class today, said he was going to go and give his DNA. It doesn't mean that Jeremy spoke in class today did it. At least one had his DNA oh my gosh, I don't even know how to say that word, taken from a discarded cigarette. Many also had their phones taken and downloaded. So they took someone's discarded cigarette and tested their DNA. They know this much, but they don't know whose DNA it is. Many also had their phones taken and downloaded. One area of the investigation had to do with a white sedan seen on camera at 1122 King Road, first glimpsed by officers on November 18th. By November 25th, police believed the car to be a white Elantra and asked law enforcement to be on the lookout for one. Precisely how the police came to believe the car was an Elantra is still unknown. A report from an analysis for the FBI dated March 21st, 2023, shows the analyst heavily relying on a video of a car heading in the wrong direction and at the wrong time on Ridge Road. A report from an analyst for the FBI dated March 21st shows the analyst heavily relying on a video of a car heading in the wrong direction and at the wrong time on Ridge Road. See, he missed the prelim. He doesn't know what evidence the grand jury was given, okay? He doesn't know, so he's like stabbing at the dark, lack of better terms. But he's literally stabbing at the dark, trying to figure out what they have. Right? I mean, like, I don't think they have to tell him how they found the Elantra until the trial, right? Like, they showed the grand jury how they came to Brian Kohberger. Whatever evidence they used in the grand jury hearing, they presented whatever evidence to them. The state's latest filing admits that somewhere within all of this, they engaged in investigative genetic genealogy, using the DNA taken from the button on the sheath, and now claims that it was due to the use of this technique that it tipped local law enforcement to investigate Mr. Kohberger. It remains unclear what the police first relied on in focusing their investigation on Mr. Kohberger. See, he wants to know. He doesn't get to know that, does he? Correct me if I'm wrong, but they don't have to show all their cards. They just have to give discovery. They don't have to explain the discovery to Mr. Kohberger. That's his attorney's job. So Ann Taylor should be able to decipher from the discovery how they first found Mr. Kohberger. No matter what came first, the car or the genetic genealogy, the investigation has provided precious little. Yeah, they present their evidence in a trial. They don't go back and forth with the defendant for months and months before a trial. That's the whole point of a trial, is to present your evidence. All the evidence is in discovery, and the defendant and in the prosecution presents that evidence in their way. I'm not wrong. They're not defending the unknown. They have to read the discovery and figure it out. It's not the prosecution's job to explain and decipher evidence for them. They give them the discovery and their attorney deciphers it. Not the prosecution doesn't decipher it for the defense. Sorry. They're not liable to explain that. Sorry, they're not. That's why he has a lawyer team. They get the evidence and they look through it and they defend him accordingly. The prosecution does not have to explain how they found Brian Kohberger if it's in the discovery. And they're saying they've handed over 51 fucking terabytes of discovery. Sorry if they haven't looked through the 51 terabytes, but maybe they should. I don't know what else to say. But the prosecution does not have to explain discovery. They have to give it to them, but they don't have to sit down and say, oh, well, we're unclear on this. Well, too fucking bad. Get an expert to sort it out for you. That's not the prosecution's job. Sorry. It's their job to turn over all discovery. And there's no secrets. A grand jury is secret. That's what a grand jury is. And the reason that they went to a grand jury was because this asshole wanted to intimidate witnesses and bring them into a prelim where they didn't need to be. They didn't need Bethany for the preliminary. They didn't need Bethany for the PCA. That's why she's not in it. Her information's not in it. He wanted to know her information. That's why he wanted her subpoenaed to the prelim. She wasn't needed there to hold him over for trial. The prosecution didn't need her. But he wanted her sitting there so he could look her in the eye after killing all her roommates except for one and a friend, Ethan, and intimidate her and not make her want to testify because he doesn't know what she's going to say. He doesn't know what she told investigators because that wasn't turned over. Do you get what I'm saying? So they said, fuck you, Brian Kohberger. We're going to have a grand jury indictment and you're not going to get to do this. No matter what came first, the car or the genetic genealogy. So they have the car information and they have the genetic genealogy. It's up to them to decipher through it. Defense gets the same evidence that the prosecution has. If they can't sift through it, that's his problem. But I guarantee you he's got enough experts and enough lawyers to decipher through the evidence. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, home, or vehicle. Yeah, there is. There's a huge explanation. Do you want to see what that is? I'm going to show you. There's a huge explanation for the lack of DNA evidence, in my opinion. This is my opinion only. And I'm going to show you what I think is the complete lack of DNA evidence. This guy studied forensics. This guy knows how to clean DNA and forensics. And this says it all to me. Look at his hands and his arms. That's why there's no DNA, because he used chemicals. I guarantee it. And that is, don't tell me that's from the handcuffs, because there's no way on God's green earth that is from handcuffs only. He used some sort of cleaning supplies or something, because those hands have seen some chemicals. Or he did something to his fingerprints. I don't know. But you can see that redness starts almost midway up his forearm. And that is not just from handcuffs. Yep, I think it's chemical burns. Look at his nails even. And this is not a filter. This is straight from... Let's see. I'll tell you where it's from. People. It's a People magazine photo of him being led into the courtroom that day. I love how people laugh. Oh, it's not. Oh, you're delusional. I might be delusional. But this is why you don't have any DNA at his office. This is why you don't have any DNA in his apartment. It's not psoriasis. It's not psoriasis. Come on, you're giving this guy psoriasis? This is a chemical burn that has healed. Okay, you got to remember it's been roughly a month and a half. Roughly a month and a half. So what was he doing in PA when he heard? Because you got to remember, guys, this plane started circling over his house a good 4 or 5 hours before they busted through the door. They busted through the door after circling his house at 4,500 feet for 5 hours. 5 hours. You're going to hear that. I mean, I live right next to an airport and I get planes landing all day long. If there was one that was circling over my house for 5 hours, I don't know what he did. But he was caught in his underwear when they busted in the door after circling his house for 5 hours at 4,500 feet. And he's sitting in his undies, bagging up garbage into separate bags. And people think he's not doing something wrong? All right, so that's one photo. Let me see if I can find another one, just to show you that it's not just one picture that this is in. I mean, obviously he did something to his hands, right? The Brian supporters crack me up. How you'll deny straight things right in your face. Now, this one was taken outside versus inside. There's no proof he was doing that in Ziploc bags. There's not? Okay, let's finish this document, and then we're going to look at that PCA, okay? Let's finish looking at this and get into this, whatever, her comforter or whatever is supposed to be in here. No matter what came first, the car or the genetic genealogy, the investigation has provided precious little. There is no connection between Mr. Kohberger and the victims. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. In essence, through the lack of disclosure and their motion to protect the genetic genealogy investigation, the state is hiding its entire case. That's a pretty bold statement. Pretty bold statement. I mean, they watched him clean his car, guys. They watched him. The state apparently thinks What lawyer uses these kind of words? The state apparently thinks that they do not need to explain how they came to think it was Mr. Kohberger's DNA on the sheath. What are they talking about? How they came to think? They didn't come to think. It was a fact. Presumably, the defense is expected to accept at face value that the sheath had touched DNA, just waiting for testing by all the FBI's myriad resources. Additionally, the defense is to guess whether the state focused its investigation on Mr. Kohberger via a bizarrely complex DNA tree experiment or through its faulty ID of the vehicle involved in this case. What?
What?
Perhaps, unsurprisingly, Mr. Kohberger does not accept that his defense does not need this information. It rather obviously falls within the ambit of Rule 16b, 4 and 5, a fact the state's briefing makes clear in its kitchen sink approach to their briefing. The state begins their argument claiming Rule 16 has no interest. Sorry. Perhaps unsurprisingly, Mr. Kohberger does not accept that his defense does not need this information. The state begins their argument claiming Rule 16 has no interest in IgG testing and then ends their argument claiming that somehow people will stop sharing their genetics if they were to realize the government is watching. What? Wait. Ends their argument claiming that somehow people will stop sharing their genetics if they were to realize the government is watching. Both arguments must fail. To begin with, the state apparently only wants to prevent Mr. Kohberger from seeing how the IgG profile was created and how many other people the FBI chose to ignore during their investigation. In essence, the state argues that if the later STR testing is accurate, then there is no reason to concern ourselves with how the state came to investigate Mr. Kohberger. State's brief at 9. What? State's brief at 9, period. What the state's argument asks this court and Mr. Kohberger to assume is that the DNA on the sheath was placed there by Mr. Kohberger and not someone else during an investigation that spans hundreds of members of law enforcement and apparently at least one lab the state refuses to name. Perhaps the most puzzling is the state's argument that while Rule 16b-5 requires them to turn over the results or reports from scientific investigations, it does not require the state to disclose what law enforcement does with the results or reports. State's brief at 14. First of all, that sounds like an admission. That the information as to how the IgG was carried out should be disclosed. Second, what law enforcement does with the results or reports is covered by Rule 16b-6, statements of prosecution witnesses, and 8, police reports. Sounds to me like they have a lot. Frankly, the fact that members of the FBI are so concerned about permitting Mr. Kohberger to know what they were up to with what was... Wait. This is him writing this. Frankly, the fact that members of the FBI are so concerned about permitting Mr. Kohberger to know what they were up to with what was supposedly his DNA does not give one the impression that there is, quote, nothing to see here, as the state seems to imply. Finally, the state's claim that ICR 16G2 applies to this matter is quite bizarre. Presumably, the independent company the government relied on was paid for its work and would stand by it in a court. The state provides no real argument as to why the company needs to be protected. Mr. Kohberger is left to suspect they wish to keep their methods from being questioned to the extent that there is some concern about intellectual property that can be addressed via a protective order that permits Mr. Kohberger and his defense team to review their work. Second, the state appears to argue that everyone living on Earth that provides genetic information is A, unaware that their DNA could be used by government, and B is an informant within the meaning of the term in the rule. Second, the state appears to argue that everyone living on Earth that provides genetic information is unaware that their DNA could be used by government and is be an informant. So in other words, they're saying there's no reason to keep the family tree secret. The state's citations to cases involving actual informants hardly help it make this incredible leap. No court has ever found the existence of a DNA informant. It would appear that the state is acknowledging that the companies are providing personal information to the state and that those companies and the government would suffer if the public were to realize it. The only two databases that allow access are ones that already inform their users, and those users can opt in to allow law enforcement searches. The statement by the government implies that the databases searched may be the ones that law enforcement is specifically barred from, which explains why they do not want to disclose their methods. If the fact that the government is looking at the genetic information that people are sharing was at all an issue, then the state's very public acknowledgement of such investigations was clearly a big mistake. So I think they're insinuating things. I don't think that they know. I think they're insinuating all of these. In any case, it's hard to understand why Mr. Kohberger should be the one to suffer, because these companies and our government choose to mislead or not educate the public. And I don't know if that's even what they said. I think they said there was just hundreds of people's names that they started with the family tree, and they want to protect those people from being associated with this case, harassed, or contacted. I don't know. According to Pew Research, in February 2020, 40% of respondents thought it was acceptable to give their data to law enforcement to solve crime. 33% said no, and 18% were unsure. However, 60% thought their genetic information could not be shared with other companies. Well, these companies all have fine print. So if a company is sharing with law enforcement something they shouldn't be, then that company will be held responsible. There is no federal law about the sharing of genetic information. See, there's no federal law. This is all bullshit. It's all bullshit. Let's see. Mr. Kohberger has reasons to be extremely suspicious of the IgG used in this case. Rather than seeing it as some sort of complex tree building that led to him, it appears far more like a lineup where the government was already aware of who they wanted to target. Rather than have the investigation done by someone blind to that fact, the FBI chose to do it themselves. Dude, the FBI always does their own fucking testing and investigation. This is stupid. I'm sorry. If you guys buy into this, this is stupid. This right here is the dumbest right here. This is akin to the police pulling in Mr. Kohberger and 5 of his cousins off the street and then pointing at him. The only authority the state has in its favor that is on point is a trial court order from a Californian case that settled before it could lead anywhere. That decision relied on is People versus Johnson. The court in Johnson was not deciding whether a defendant had a right to know how he was identified, only that his identification could come into trial without a mini trial about it. A better case is State versus Artiga. In this case, the appellate court heard similar arguments about the need for software used for facial recognition and to be discovered to the defendant, though they would not be admitted at trial. The court, considering the matter, found we are keenly aware the cases we have discussed involving incidences concerning Fry hearings and potential expert testimony, and that here we are dealing with eyewitnesses who have already identified the perpetrator and the ID found admissible under Wade. However, the facts of this case convince us the defendant will be deprived of due process if he does not have access to the raw materials integral in the building of an effective defense. The evidence sought here is directly tied to the defense's ability to test the reliability of the FRT, As such, it is vital to impeach the witness's identification, challenge the state's investigation, create reasonable doubt, and demonstrate third-party guilt. The FRT's reliability has obvious implications for the accuracy of the ID process because an array constructed around a mistaken potential match would leave the witness with no actual perpetrator to choose. The reliability of technology bears direct relevance to the quality and thoroughness of the broader criminal investigation and whether the potential matches the software returned yielded any other viable alternative suspects. Defendant's request for the identity, design, specification, and operation of the program or programs used for analysis and the database or databases used for comparison. At trial, the state will likely have the investigating officer explain the police investigation, including the process of retrieving the still photo from the surveillance cameras, ultimately to generate an image of the defendant. Although we do not speculate regarding the exact nature of this testimony and whether defendant will seek to impeach it, the fact the state does not bear the burden of adducing testimony regarding the composition of the photo array does not bar the defense access to the discovery sought. So this is going to be up to the judge. Mr. Kohberger finds himself in a similar position as Mr. Ortega. A massive investigation came to focus on him and him alone. The state appears to be trying to hide its original domino such that he cannot discover why. Mr. Kohberger has a right to discover and question the investigation that led to him. This court should so find. I'm going to address chat right now. I'm going to address being respectful. I think that there are some people that have been disrespectful, and it has been noticed. So my moderators are clear on what I expect and what I like in my chat and what I don't like. So please don't undermine my moderators. They have a wrench for a reason. They will determine what's respectful and what's not. All right, so that was the end of that, and I just think it's a bunch of mumbo jumbo, in my opinion. I don't believe the state's hiding their case. They gave 51 terabytes of evidence. Totally, that sounds like him. And I think that Ann Taylor, she's got to defend him. I mean, she's doing her job. I think it's a bunch of bullshit, but all right, here's the search warrant from PA. and I read that and I still didn't hear anything about her comforter. So I don't know what you guys are talking about the comforter. But I would have to admit that maybe Kaylee and Maddie's boyfriend's DNA would be on their beds. Just saying. Or if any boy was in their room and sat on their bed, I mean, there'd be DNA everywhere. We already know this. Hold on, I'm just scrolling through this. And I think something happened at 735 Nez Pierce that night at that frat party before they came home. Let's see. I thought there was more of a description of when they went into the house in Pennsylvania, no? Where did we read that about him separating the garbage. I thought it was in here. It's not. Where did we hear that, you guys? Where did we hear about him separating garbage? Do you guys remember where that came from? The news. Brian Kohberger was allegedly rummaging through his garbage wearing here it is. I found it. It came out in a news article. So let's see. Let's read through it. Brian Kohberger was allegedly rummaging through his garbage, wearing latex gloves in his parents' PA home when police arrested him. The 28-year-old suspect was allegedly carefully sifting through trash in his parents' kitchen when authorities took him into custody, which one prosecutor said was an apparent attempt to cover his tracks. Kohberger was found awake in the kitchen. This is a quote. Kohberger was, quote, found awake in the kitchen area dressed in shorts and a shirt. So he wasn't in his undies. But they took his undies. When investigators stormed his parents' house on December 30th at approximately 1:30 a.m. And that was a quote, found awake in the kitchen area dressed in shorts and a shirt, from Michael Mancuso, the Monroe County First Assistant District Attorney. At the time, he said, quote, and yes, this is a quote from the damn district attorney. Just saying. This is a quote from the prosecutor in PA.
Eddie.
He was wearing latex medical type gloves and apparently was taking his personal trash and putting it into separate Ziploc baggies with his red ass hands and his white ass nails. The seized items referenced by Mancuso were previously documented in police search warrants. However, the prosecutor's recent comments provide fresh context regarding exactly what Kohberger was allegedly doing at the exact moment police busted him. Kohberger's actions, prosecutors added, could help explain why days earlier authorities had failed in attempting to obtain Kohberger's DNA by searching through the family's trash. So he didn't put his trash in there. That's why they had to get his dad's. Investigators had then collected forensic evidence belonging to Kohberger's family members, including his father, but not from Kohberger, because he made sure his garbage wasn't in there. He's a criminology PhD student. Since the quadruple murder, the Pennsylvania prosecutor also speculated Kohberger had become savvy at obscuring his forensic footprint. It could very well, this is a quote from the prosecutor in Pennsylvania, it could very well explain some of the other aspects of the case from Idaho, some of the lengths a person would go to avoid having their DNA left behind when they know or should have known that there was an investigation underway. So how is Brian Kohberger going to explain that not even his own DNA was in his office? How is he going to explain that? Why'd you clean your own DNA, motherfucker? Why would you do that? If you're not guilty, why are you sitting at 1:30 in the morning with gloves on, putting your trash into separate bags? Why is your office clean with not even your own DNA? Why does your apartment not have your DNA? Where is your DNA and why is it cleaned? Doesn't make sense. You come into my house and my DNA is everywhere. But if I'm accused of a crime and you come in my house and my DNA is not even here, don't you think they're going to wonder why? Come on. Your DNA is all over your shit. He has an office that he worked in that has no DNA in it. It's because he cleaned it. He knows how to clean DNA. That's why there was a latent print, right? Because he cleaned it. A latent print is not visible to the naked eye. Miss Potts, I'm taking the word of a prosecutor over some YouTuber, okay? Give me a break. They're going to bring it out at trial, okay? That's when they give their bombs. They don't give their bombs in motions to Brian Kohberger because that's what he wants. No, Brian Kohberger, you're going to have to defend yourself. You're going to have to work with your attorney and you're going to have to sift through it. How do I know he cleaned it? Because there was molecular components of blood on a footprint that wasn't visible to the naked eye. So obviously someone cleaned the blood or it was tracked to where it eventually was not visible and left a print. That's how I know. Bleach, Magdalena, bleach.
Shall we play a game?
That's what Brian Kohberger was thinking throughout this whole thing. Shall we play a game? I'm sure they have proof of it, Brittany, because there's body cam. Right? This was a raid. They circled his house for 5 hours before busting in the door. I mean, he had two. Listen to this. Here's another one. I think he's going to plead guilty is what I think. I think you're right, Maiden Nut. I don't think there'll be a trial, but I think this motherfucker is going to push every envelope and realize he's backed into a corner because he's a dumbass. Because he's a dumbass. You don't know why the print was latent. We don't know why the print was latent. The print could be latent because they stepped in blood and tracked it and it eventually wore off and it just left a little remnant, or it could be because it was cleaned. I think they knew who Brian Kohberger was when he was being a freak before the murders. That's what I think. During the December search warrant of Kohberger's home, authorities also seized a pair of his size 13 Nike shoes, a black Washington State Cougar sweatshirt, his underwear, black socks and shorts, and other items. 4 medical-style gloves, a white T-shirt, and a silver flashlight were recovered by investigators. State police had previously petitioned the courts to allow troopers to carry out the raid at night. A cheek swab that was performed on Kohberger on the night police arrested him was also key in building the murder case against him. Kohberger's DNA obtained during the search warrant ultimately matched the snap button for the sheath of the knife. Investigators are also probing the possibility Kohberger could be behind another unsolved killings in Pennsylvania. And he previously waived his right to a speedy trial. No, they didn't say what size the shoe was. No, they didn't. Here, we'll go back to the PCA. No, I don't think they did. I think they said just a diamond sole, didn't they? Let's see. Oh, let's also talk about the fact that he shared his WSU office with 2 other students. He shared the office with 2 other students, but there's no DNA in that office. The fucker cleaned it. I think they know. I think they'll be able to map out exactly what he did. He's screwed. What was I looking up again? He has proper defense. What was I looking for in here again? Now I forgot. Oh, the latent shoe print. Okay, yeah. No, it doesn't say what size. It says, during the processing of the crime scene, investigators found a latent shoe print. This was located during the second processing of the crime scene by the ISP forensic team by first using a presumptive blood test and then amino black, a protein stain that detects the presence of cellular material. The detected shoe print showed a diamond-shaped pattern similar to the pattern of a Vans type shoe sole, just outside the door of Mortenson's bedroom, located on the second floor. This is consistent with Mortenson's statement regarding the suspect's path of travel. No shoe size. But they did take a pair of size 13 shoes from Kohberger's house, according to this. Hold on. It is also believed Kohberger's white Hyundai Elantra, suspect vehicle 1, is stored in the 2-car garage. Based off the above facts, I'm requesting a search warrant for the car. And we don't know if they found anything in the car or not. You got to remember, everything's sealed. Sealed. All right, let me come over into chat and see what you guys are saying. Pretty intense. I mean, everybody has a different opinion, and that's okay. But we need to have respect for one another. Anne says DNA submitted to 23andMe and Ancestry do allow law enforcement to use their information. I think some of them you have to actually opt in. I'm not sure. Opt out, maybe. I just feel like you shouldn't give your DNA to anybody. We don't know that one, Maiden. You can't say that as a fact. How can you cannot say that. You don't know what was in the car. We have no idea. We've got no reports of what was in that car. I don't have to. L-Wing W. That's the thing. Innocent until proven guilty doesn't mean we have to respect Brian Kohberger. Okay? We don't have to respect Brian Kohberger just because he's innocent until proven guilty. Nope. That's in a court of law. That is in a court of law. We're not in a court of law. We're in a YouTube live where we're going over factual documents and discussing it. Innocent until proven guilty doesn't equal respect. But you should respect innocent victims. That's who you should respect. And clearly, if you're talking about victims' body parts being cut off on a live stream, you clearly are not respecting the victims. So I have a very big problem with people who respect Brian Kohberger, but don't respect the deceased victims. Huge. Huge. We do not have memberships here, Trina. If you would like to be a part of our Patreon, you can join the Patreon. This channel is not monetized, so I'm strictly independent. We don't know, Erica, if there's any DNA. You don't know. Elwing, you don't respect humanity. How about that? You don't respect humanity. And that's how I feel about you. Miss Potts, the discovery is sealed. The discovery is sealed. You haven't seen anything, Miss Potts. The discovery turned over by the prosecution shows no victim DNA in his car, apartment, office, or parents' house. The bottom line is you guys don't know what's in the discovery because it's sealed. But hey, whatever you guys want to think.
If you say Ferris Bueller, you lose a testicle.
If you say respect Brian Kohberger, you lose a testicle. I don't have to respect Brian Kohberger. But, because that doesn't equal innocent until proven guilty.
Brian Kohberger. You know what I have to say to ANC Taylor, the defense lawyer? Bring it on, woman.
But this is why we have trials and juries. And a jury and a judge will decide on all of these motions we just read through. And I believe in innocent until proven guilty. But you don't go around... If you believe in innocent until proven guilty, then you shouldn't be spreading rumors about the victim's injuries. So in my opinion, you don't respect the Constitution if you're willing to put mad bullshit out there about victims. Dinky. So you dispute the defense's statement of fact? Yes, I do. Yep, I dispute some of the defense's motions. Yes, I do. And you don't. You're right, J. Lord. J. Lord has a good point. J. Lord says, I don't have to think he's innocent either. That's for the court, not me. You're right. You don't. You are completely right. Someone in here could be a juror. Okay. And what's your point on that? That someone in here could be a juror. Okay. Sussburger. I love it. Yes.
You know Don's full of shit.
Brutalizing people, not charges equally. Yes, it is. I mean, you guys don't even think about the fact that Jack D had a girlfriend since middle school, Miss Potts. Miss Potts, I'd like to know how you feel about this. Don't yell, Erica. Don't yell. Miss Potts, sworn statements by the defense assert the discovery evidence turned over show no victim DNA in car, apartment, office. Yes, I'm going to take a sworn statement as fact from either side. Well, it doesn't seem to me like you're taking the facts from the prosecution only for Sussburger. I'm not judging whether you should respect him. I'm saying I don't have to respect Brian Kohberger because I don't have respect for people that kill and play games with victims and intimidate witnesses. In my eyes, those people are pieces of shit. So From what I've seen, that's what's been going on here. And all these motions just continue to add up to more and more games. I think you guys should also respect the process. Respect the process and let it play out in a court of law. We're not doing a mini trial because Brian Kohberger wants one. Okay? That's the bottom line. We don't have to do a mini trial. The prosecution doesn't have to do a mini trial because he wants one. Because he wants them to explain what they've got on him. Because he just can't wait. Because he's a weirdo. And that's why they have exactly dark horse. That's why they have jury selection. If there's a tainted juror, don't worry. The defense will weed it out. Well, let's see how the state responds, Miss Potts. That's what we do. So now we wait for the next response. And then we have the hearing on, is it Tuesday, Monday or Tuesday? I know you guys want a mini trial like Brian because you're so impatient. Damned Schizo. Miss Potts is a YouTuber using a fake profile. Who is it, Damned Schizo? I have an idea. Who is it, Damned Schizo? It's okay. You can out him here. Did the defense ask for all the tips called in and sent in? I think they did. Yeah, they wanted every tip. I don't have him in front of a firing squad. I'm waiting for a trial. Isn't that what we're supposed to do, Dinky? You've got him free. You've got him innocent. That's more dangerous in my opinion. If you use logical thinking and say Brian is innocent, which I think he is, that means the killers are still out there, Mystical Bandit says. Julez. I don't even know who that is. Who's Jules? People keep coming in here talking about this person. Who is it? Suzanne. Anne just can't even deal with all the evidence. I don't know. Someone said it's a YouTuber. I'm waiting for them to say who it was. We get a lot of YouTubers that make names and come in. Not a lot. There's a few. There's a handful. And we try to weed them out, but I don't know who Jules is, so that's not definitely who I was thinking. One-eyed Flo, she's just putting it all out there. She says, I'd shoot now, but that's just me. Why waste this money? There, I said it, in my opinion. You're entitled to that. Rose Renee, sounds like some people are just upset that the facts aren't supporting Brian B. Lynch. Nope. Love. Yeah, don't call me love. We all want the facts, not only wanting him hung. How about finding out if he actually is the perp? Love. I don't think that the jurors are going to have to be sequestered. Do you guys? They weren't in the Daybell trial. Why would they need to be sequestered? Jules of all trades? Never heard of her. Jules is the one who read the document wrong? I don't even know who that is. What's up, Doc City Crimes Investigates? Hey, Mike Sanner. Kanji says this is true crime, not Days of Our Lives. We're all mad here. Why would you assume that the knife sheath was placed there by someone? Why would you assume that before assuming that this guy did it? Oh, I don't know who that is. Yikes. They might move it. You know that's coming next, though. He's going to challenge everything. He's going to challenge the indictment. He's going to challenge everything. The DNA, all the evidence. He's going to scrutinize every witness. I know. Leo, you have free reign, girl. You have free reign. You've put up with it for 3 hours. It's been 3 hours of that. Leo Tech, I give you free reign to handle that. Because quite frankly, I'm sick of like seeing that person laughing at the host of this channel. It's very disrespectful. No, I don't know how someone read it wrong. I mean, it's all in black and white. They're all there. And we've gone through all the documents now. We are caught up, but we don't have to get angry at each other, okay? So let's not end this on a bad note. Let's go back to the boob tube. I have a video I'm working on. I want to give you guys an update. We don't have to hate on each other, okay? Let's just keep other people's channels on their channels. They do things the way they do them. And if you don't like the way they do them, don't watch them. That's all I'm going to say. But we're not going to, I don't know who this Jules person is. I don't know how she does things, and I don't know what she's done. And I don't want any negativity coming from my channel to another creator's channel. Jules is for Justice is her name. Are you really?
Jeepers.
Right? J Lord, I don't get it. I've never seen in 53 years people worried about the accused killer ever, ever, ever. Me either. This world is becoming really sick, to be honest. The people that love Brian Kohberger are the people that are probably writing him right now. All right, let's go to the boob tube, and we're going to do a little preview of what is to come. I've been working on this, and it's just the very beginnings. So I never really do like a longer video, but this one I'm going to take my time on because, and it's Natalie Holloway. So we know that Joran Vandersloot, a.k.a. Urine. And if you don't like Joran Vandersloot, oh, you know what? Maybe I shouldn't talk about Joran Vandersloot because he's innocent until proven guilty. Come on. He's a piece of shit. Piece of shit. Oh, Jewels of all trades. I don't know who that is. I'm sorry, I just don't. All right, we're gonna get to this sneak peek for you. I put it in our Patreon last night, and if you'd like to become a Patreon, you get access to new things. I get your opinions. We're trying to grow the channel. We're trying to get to 100,000 subscribers. If you want to be a part of that journey, please do join me over on my Patreon. And now we're going to watch this. Aruba. Natalie Holloway, a vivacious and ambitious young woman, hailed from Clinton, Mississippi. Born into a loving family, Natalie was full of dreams and aspirations. Natalie's vibrant smile, sparkling blue eyes, and compassionate heart drew people to her effortlessly. Her friends and family adored her, and she possessed a magnetic energy that left a lasting impression on everyone she encountered. She had just graduated from high school and was eager to embrace the freedom of youth before starting her college journey. Natalie's adventurous spirit led her to the tropical paradise of Aruba, a destination known for its beautiful turquoise waters, the sandy beaches, and of course, some wild nightlife. The journey Natalie embarked upon was meant to be a joyous vacation, a chance to create unforgettable memories with her high school friends. She relished the island's splendors, basking under the warm Caribbean sun and exploring hidden coves. Natalie embraced the vibrant culture, dancing to the rhythmic beats of Aruba's music and immersing herself in the local way of life. However, tragedy struck on that ill-fated evening. Natalie and her friends decided to venture out for the night, lured by the allure of Aruba's vibrant nightlife. Little did they know that this adventure would forever change their lives. And that is my sneak peek of my video I'm working on with the Natalie Holloway case. So I know a lot of you guys are remembering that. You remember the Nancy Grace every night. You remember the Greta Van Susteren. Greta Van Susteren sat down with urine. And I actually have a Facebook page that I made years and years and years ago. It's called Urine Vandersloot is a Scum. It's on Facebook. If you want to like it, go like it. But yeah, we're going to be talking about Natalie Holloway. Urine Vandersloot was in court yesterday, and this is going to be a slow process. So I expect Urine Vandersloot to be here for years. I think this is going to be a long process for the Natalie Holloway situation here. Now that they finally have him on U.S. soil, it's going to be really interesting. So I want to show you guys before we end, I want to show you his newest mugshot, the newest mugshot of Urine Vandersloot. And this was taken in Mississippi, or Alabama, rather. And there it is. There is Urine Vandersloot circa 2023, June 2023. There's the current mugshot. So we're going to be covering this real soon. I'm going to be working on this and making it pretty detailed because I invested a lot into the Natalie Holloway. I too watched coverage every night and waited with bated breath to see if she was found. So he's starting to look more and more like his dad at the older he gets. But he was already convicted of killing a girl in Peru. And now he is on U.S. soil to face charges of extorting Natalie's parents. Oh, he's happy, I think, to be here, Leotech. Leotech says, oh, and he's still smiling. I think he's happy to be here because the Peruvian jails are not anything like what he gets here. So he's probably going to enjoy his few years here on American soil. And unfortunately, in federal court, there's no cameras. So we will follow the case through documents as we can and through the sketch artist. So we will we'll follow up on this and hopefully they get some answers, because I know there's been a lot of talk about Natalie Holloway possibly being trafficked. I mean, he even said he had a guy come to him and ask him for a blonde girl. So we don't know. We don't know. She's never been found. And we hope for answers in Natalie Holloway's case. And this wraps up our Saturday live stream. This is always a long one because we just take our time and talk through. And I hope you guys enjoy the rest of your Saturday and the rest of your weekend and get lots done. Spend some time with family. And you guys don't leave here mad ever. Don't ever leave mad. We are all friends. We can disagree. We can be argumentative and all that. But at the end of the day, we are all on the same side. We're all human beings and we all need to get along. So respect each other's opinions. Just don't do anything deliberately to hurt victims.
So is that a joint? Or is it a cigar?
All right, you guys. Good night. Good night. What am I saying? Good night. What are you talking about, J Lord? Everybody stay safe out there, okay? I'll talk to you guys soon. Dance it out. Have fun.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. I don't give a damn. I don't give
Good night.
You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time, I ain't got time, I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs. Buying new shoes, hanging by the pool, sipping on Coke and Jack. Calling my phone when you feel alone, but I'll never call.
Brian Kohberger.
Did I ask you why are people such idiots?
KB, it's we have to stand down.
Yikes. Bananas, B-A-N-A-N-A-N.
Thanks so much, Jennifer.
Just based on my observation.
I don't want Jennifer or two Jennifers.